So my name is Steph Della Cuesta. I'm one of the solicitors at the Goldfields Community Legal Centre. So a little bit about me and my background. I used to work for a law firm in Perth where we specialise in deceased estates. So I suppose all the weird and wonderful, lovely things that happens after someone's died and happens when people are grieving. I suppose I've seen lots of things, not good, wonderful things. So I've seen a lot of the other side of what happened. So I'm encouraging everyone now to please have some form of a will. So a will, why you should have a legally valid will. It ensures you have peace of mind in knowing that people who you choose to benefit from your estate will be the people who receive your estate. So you get to choose who your executor is. Hopefully it's someone that you trust to distribute, follow your wishes, things like that. This person is obviously going to know the ins and outs of everything that you had in your life as well, so just keep that in mind. You also get to choose your funeral wishes, so whether you'd be cremated or buried and if you'd want your organs donated. Please keep in mind that sometimes the will isn't found until after all the funeral things have happened. So we also say that funeral wishes, please let your friends and family and whoever else know what your wishes are for your remains, because sometimes the will is found after the fact. You also get to choose who receives your gifts, so any specific gifts that you may have. I know in my family we have a weird obsession with fancy dinner sets that my great-grandparents brought over from England, so we fortunately get all these wonderful dinner sets that are in a lovely cabinet at the moment. Any other gifts that you may have, that includes jewellery, anything that you want to specifically go to a particular person, these are the things that you get to choose in your will. And if people have any minors, children under 18, they also get to choose who may be the guardian of those children if they are the sole parent when the person's passed away. You can also choose who obviously gets different portions of your estate. So I know I've spoken to a few ladies around this morning and the other night that sometimes they think one child might need more help than the other. So in your will you get to choose these portions of how much everyone gets or what percentage everyone gets as well. So back to your executor. So they are the person named in the will that carry out your wishes after you've passed away. They organise and collect the assets, all of your assets and your debts, and distribute the property as set out in your will. If you pass away without a will, that means that you have passed away intestate. And if you pass away intestate, your estate is distributed in accordance with this lovely piece of legislation called the Administration Act. So you don't get to choose who your administrator is or how your estate is left. The Administration Act basically sets out every scenario, so who you're survived by, whether it may be a spouse, whether it may be children, if you don't have a spouse and children, whether it may be siblings or parents or nieces and nephews. So the Act sets out for pretty much most scenarios, and that's how your estate will be divided if you don't have a will. It's all set out in this lovely piece of legislation. Can your will or estate be contested? Yes, it can, but not by everyone. So there's another lovely piece of legislation called the Family Provision Act. That gives us a list of eligible people who may be eligible to contest your estate. If they're not within those realms, then they can't contest. So one example I like to use is estranged children. People think, oh, I haven't spoken to them for 20 years, they don't need anything from me. Once someone has died, people come out of the woodwork. You would be amazed. So just keep that in mind. But when you have a will drafted, these are all the things that your lawyer should be able to tell you and you should be advised at the time. So about who may be eligible to contest your will, executor's duties, what might happen, your funeral wishes. These are all the things that you get advised on when a will is drafted. If you don't have a will, you probably won't get this advice. And then if you've passed away intestate, your choices and your wishes, they don't get noticed. So keeping that in mind. So everyone please think about a will at least, even if you're jotting down some ideas. At the Goldfields Community Legal Centre, we can help draft with wills, enduring a power of attorneys and enduring power of guardianships. Even if you're not wanting to draft one but just wanting some advice, we can help you out. I know that Mr. Gray is here around somewhere. He can also help out with the same wills and deceased estates advice. But I think that's my quick spiel for today. Did anyone have any questions?
So if you pass away in Perth, or they've got facilities or you're on life support, they can actually harvest your organs from that point of view, not from here, not from Esperance. So, yeah, basically. And also another thing, if somebody puts in their will that they want to be donated to science, that's a whole different issue, and it depends on the University of WA whether they have a spot for your body. They can actually say, no, sorry, there's a whole pile of criteria that you have to go through, that whether they accept you or not as well. So as much as you put it in your will, it doesn't necessarily mean that it's going to happen.
Just they're always encouraging people to be organised.
Absolutely. That's right, yeah. So Capital City is probably the only spot. Yep, thank you.
Yeah. That was new information for me as well. I wasn't sure of the schematics of how everything worked. I just know that if you are an organ donor, it can be placed in your will, and we can have your organ donor number and everything included as well.
Just to follow up on that, we can't predict where we're going to be when we're deceased, and it may be that we are flown up to Perth or in Perth when it actually happens. So I wouldn't say don't put down an organ donor just because you feel you live in Esperance and it's not going to do anything. It would be best if you wanted to do that, definitely put it down, because you just may end up, that it works out for the hospital and works out for other people. So don't let that be a limiting factor because you live in Esperance.
I suppose expanding on that, that's also an after the fact thing as well. So make sure you let people know that you want to be an organ donor or that you want your organs donated, because sometimes if you've been buried or cremated, we can't get them back. So if you, I suppose, pass away with significant amount of assets, at least you have a house or nice lot of money in the bank. If you pass away with a will, your executor will apply for something called probate. It's an affidavit your executor has to sign. They also have to send through your death certificate to Supreme Court and give a list of your assets at the date of your assets and liabilities at the date of your passing. So for that instance, if they wanted to find out if grandma had a probate, they can apply to the Supreme Court and ask if probate was made. It just depends on what kind of assets you had. Not everyone needs a probate. Sometimes people just die with $90 in the bank. Go to the bank, everyone signs a form, consents to the money being dispersed. I had a lady the other day, the bank wouldn't give her the $90, her and her sister. The bank told her she needed to go and get a grant from the Supreme Court. To apply for the grant, it's $370. So we just sorted her out, helped out with the forms. Bank said, oh, okay, this is all she's got, this $90, sure. The two beneficiaries can have it, and they dispersed it. The bank's always going to tell you need a grant. You're not always going to need a grant. So please seek some legal advice if that's what you've been told, especially if it's something like $90. But in terms of the will, unless there is a probate, all you can really do is ask the executor. But if you're not a person entitled to the information, they don't need to give it to you either. So it's all about trying to fact find on your own. No, that's fair enough. And unfortunately, it's only the executor that can give that information, and if other beneficiaries want to let everyone else know as well. But as far as a practical sense, if there was a probate, you can apply to the Supreme Court and ask or you can ring up and ask sometimes. You get a nice person on the phone and they'll tell you if probate was made. Yes, that's something that we can help out with, but if he's 17, I'll need him to come with a guardian as well. So once your will is made, you must store it in a secure place. There is something called the WA Will Bank. It's run by the public trustee. If you were to, they have a form online. You can fill it out, send it in with your will. They store it for free. If you don't want to store it there, you can store it if you have a safe at home. Private lawyers usually offer free storage or some sort of storage for your will if they've drafted it. Sometimes your accountant will, but please just make sure wherever your will is stored that your friends and family, especially your executor, know where to find it as well. But Will Bank, there should be a downloadable form. It's free to deposit your will there. To get it out, usually all the person would need is a copy of your death certificate, their ID, and they have to be the executor to be the one to get it out, not Joe Bloggs down the road. You have to be the named executor in the will. You won't get a death certificate until after there's been a funeral. It takes a few weeks. I think you guys have to sign off on that. It goes to birth, deaths and marriages, and then it will get sent. The death certificate gets sent out. So if you need probate, the executor will have to apply for probate. They will need to execute an affidavit. They'll need the original copy of your death certificate, and they'll need to give the court it's called a Rule 9B. It's a statement of assets and liabilities of everything that you owned solely in your name at the date of your passing. And that needs to be given to the Supreme Court with the $370 fee. Court then says, yeah, great, executor. Court then sends the executor back this lovely piece of parchment with a big red stamp on it and says that this person's the executor and they have the authority to act on behalf of the estate. Does that answer your question? Yeah? Yeah. So basically, if you're an executor and you get a bit stuck, please just seek some legal advice. It is a really big job. And if you haven't done it before, it's really confusing and you're not sure where to start. That's something that we can help out with. That's something a private lawyer can help out with. It's completely your preference. Usually that's the preference, especially because sometimes your executor is either your spouse or your children. Trying to think about legal things and being asked questions and being told to do things while you're grieving gets a bit hard. So I know I've had a few people in the past that their husband or wife has passed away and the children were the executors, that after that first spouse has passed away, the survivor changed their will to a friend because it was just too much on their children. So I suppose that's also something to think about when you're drafting your will as well, as whoever you make your executor has to be the person. They're the person to do everything. So they make sure the bank's closed, Centrelink payments are stopped, utilities stopped, your house is going to be sold. There are all these things that have to be done. So you just keep in mind that this person has to do all these things as well as manage all the money and give it to everyone that is entitled to it. Yes, you can have more than one executor. They can be joint or act separately. That's something that you get advice on once your will is drafted if it was done by a lawyer. Executors can be beneficiaries, yes. Normally, in the past, it's been the eldest son, I don't know if that resonates with anyone, has been the executor, and then the son and the rest of the kids are the beneficiaries. That's a normal scenario. In terms of wills, there is homemade wills, but I very much don't like them because they come with mistakes. And when there's mistakes, it may make your will invalid, and then your estate might be subject to an intestate estate, and therefore your wishes may not be followed through. So my preference is, even if you still want to do a homemade will, I mean, a will in general is lovely, but please just seek some advice and make sure that there's no mistakes, everything's drafted correctly, just because we want your wishes to be followed through, not, you know, something's happened and then all of a sudden your will, it's invalid and it can't be followed.
We were talking about wills, and you know, quite a few people that come to the Death Cafe have had experience of not having them. And I said, why don't we get some t-shirts printed? We're all going to die. Have you made your will? Wouldn't we love? Because apparently, what's the percentage of people, Steph, who haven't done their will? And that's what we're all about here, especially at the Death Cafe, is taking control of our own end of life. And part of that is to make it easier for our children and whoever's after us, because it's so stressful for our families to come home, especially when they don't live locally, and deal with all this stuff. So that's what we're about. And part of that, you know, having a will, is also having an advanced health directive. We've got some up on the Death Cafe table there. They've brought a new form out. When was that, girls? Not last year, the year before? Anyway, if you've got an old health directive that's more than 3 years old, they still function, but these new ones are much better in that you can have much more personal input into it. The palliative care WA people printed a heap of cards, and they were called Dying to Talk cards. So the way is to spread them out, put them into sections of what's important to you, what's not important to you, so that when you're doing your health directive, you fill all that out at the beginning, what's important to you, because when you come to the second part of the form, it's going to ask you what do you consent to and what you don't consent to. So that way you can sort of say, well, I only want, for instance, hydration if I'm going to be able to see my family. They've got to come here, so only for that long, and I don't want long term. But in order for that to make sense, you have to put in the beginning of the form what your good life is. So I've done, taken the liberty of doing a list of all those little comments from their cards and from other cards that come from other organisations. So you can take one of those lists and take a form and go through it and try and get your advanced health directive done, because that's your power to make your own decisions. You don't want your kids or your family standing around your bed if you've had something go wrong, and they've got to make a decision about whether you want to be kept alive or don't. Make that decision now. When we're of sound mind, again, that's another thing. Once you're diagnosed with dementia, you can't do any paperwork like that. So make them now. They might never be used. They're only going to be used if you can't speak for yourself. But it's just a way to have that power over your own medical situation. So Meredith and I are going to be doing little short workshops. Last year in this space, 53 people came and did the workshop with Irene. Any of those people here today? Yeah. Have you filled out your Advanced Health Directive yet? So the reason is I'm asking is because Irene got from the government 53 of those packages, and they're getting a bit, you know, mean now on handing them out. We're paying for them all, and they want people to do it online. So I have got some of the original kits up there, but I'm just asking people, when you've used them and when you've filled your form in, to bring them back so that we can share them with other people. But we can still get more, but we don't want boxes and boxes of them that are going to be sitting in somebody's cupboard. So please go up, grab a form, grab one of those sheets and just have a look at it. You're not going to do it in 5 minutes. It's quite a process, but it's up to you to list down what your good life is. And then you can fill the form out according to that. And Meredith and I will be having a few little workshops through the year. We'll just use the lounge room just to help people work through that when it's hard to do so.
It's probably quite a good idea to let your children know why you've done what you've done, because when you've died, you can't go back and answer the questions, because sometimes with families, they're not, maybe they're not even or whatever, and families then have a big discussion, well, how come you got this and I only got this? So maybe have a discussion with your children as to let them know why you've dispersed what you've dispersed.
Yeah, that's a good idea. Yeah. And also, talking about the advanced health directives, on that note, Heather, is to give your children a copy of it, because they need to know before the event what your thoughts are. You know, we don't want them to race back to Esperance and say, oh no, we've got to save Mum. No, we don't. Mum's made this decision a long time ago. So make it your choice about what you want.